Greetings, everyone. Thank you for joining today. Got an interesting subject that we want to go over. Um, I would like to share with you all an additional step that we're taking in regards to the Internal Revenue Service. We understand that since we've been talking about these subjects and implementing certain procedures, they have taken what we have done and found a way to change up the script rather than trying to come after us, in the ways that they normally like to do that. Instead, they rather just change the process and try to confuse us or delay our process in receiving certain correspondences, as most of you have um, experienced. So, in addition to what you've learned as far as gathering specific EIN numbers that are established under the Equitable Fiscal Responsibility Act, otherwise known as TEFRA, and all of the other processes that you found in the course, we're going to submit what's called a restraining order in the same sense that we've done the same thing with the sheriff's departments in your counties, with the chief justice at the superior court level, your state governor, and the attorney generals. We're going to do the very same thing for the IRS, for the Internal Revenue Service. Okay. Now, there are specific parties that we have to notify. What we have uncovered in doing this process, a few of our members have indeed been placed on that do not tax list. I mean, everybody knows that that exists. If you were to obtain a specific EIN number for your foreign express trust, having a foreign trustee to exempt you from the US court test and the US control test. So there is such a thing as a no tax list. This extra step in forcing this restraining order and showing how all of the taxes that you've paid in the past and all of the taxes that they're trying to continue to pillage from your estate is considered voluntary or involuntary slavery, which was abolished long before the existence of the United States. And that would make the 16th Amendment null and void. So it's all about serving specific documentation, proving it with congressional records, which we have, and other treaty laws. This is going back to the treaty laws that I talked about. I'm now going to show that to you in this webinar, and you'll see how to implement it. Now, we're going to show you how to do it here and why we're doing what we're doing. The actual document will be for you guys to submit your application to us, and we'll get it drafted for you and send it out. Okay, that's how we're going to do it to protect the information. We've had issues in the past with or dishonorable people. And the whole point is to protect the information so that the other people on the other side receiving this cannot study it and try to make additional changes, so to speak. We want you guys to use these measures as quickly as possible to obtain your personal endeavors. All right. So let's get down into the webinar. All right. So this is the Internal Revenue Service injunction. Right. That is a Latin phrase or a legal phrase for restraining order. And this is going to be done as a constitutional challenge. If you were to look up all of the rules in the Federal Rules of Civil Procedure, you will find 1, 2, 3, 4, 5, 6, all the way down. However, they hide the constitutional challenge on the surface. You have to know exactly what the number system is for that in order to find it. So they don't show you that it is 5, and they don't show you that it is 6. It is actually 5.1. That's how they've done that. So a constitutional challenge allows you to question the validity of a statute or code, which is enforced by the Attorney General in your state or the United States Attorney General for the federal Constitution. It allows you to question any code or statute that comes after the original Constitution. That's the whole point of a constitutional challenge. So in this webinar, we are going to be discussing even further how your foreign express trust is determined to be foreign from the United States, otherwise known as Washington, D.C., and the writings directly from the law that supports having a non-resident alien as your foreign fiduciary, which is highly imperative to ensure that the trust remains outside of the U.S. court test and U.S. control test. For what? Zero tax liability. After this, we'll do a recap. Or after this recap, we will go into the actual tax restraining order that is directed to the current IRS commissioner, the Chief Justice, the IRS Chief Taxpayer Experience Officer, the State Controller, otherwise known as the Chief Financial Officer in your state when it comes to state taxes, and the U.S. Court of Federal Claims. All right. Now, sometimes it might even be a good idea to submit an actual 1041 form with your trust with this actual restraining order. So that way you may receive monies back from monies you've paid in the past. This is how we're going to do this. This is the big question that most of you have been wondering about. Now, who is this for? The restraining order can be used if you are currently on a payment plan to pay the IRS, or if you were planning to submit a payment on an alleged tax bill you received from the IRS, which is unverified, might I add. What do I mean by that? In Title 26, anytime they send you a statement in the mail saying you owe a tax, it needs to be verified. It needs to have someone sign under penalty of perjury that the statements in that document saying that you owe X amount of dollars, that they're saying this is true and correct, and we can prove how you owe us. No, they cannot. Neither in child support. Did the husband ever receive anything of valuable consideration from the wife for the state to intervene and say, you have some form of a promissory note that you have received or given to the wife, and therefore you must give the wife X amount of dollars per month, collected by the state to be distributed to the child. And yet the father is in the child's life doing everything that he needs to do. That happens a lot of times. In most cases, that's what's happening. And so these things need to be verified. It's not just child support. It's taxes, it's spousal support, it's many other things, even going into bankruptcy court. Now, what if you've applied for a passport and you was denied because of an amount allegedly owed to the IRS or child support in an amount above $2,500? Then this is for you. You have nothing to lose. You need to send this restraining order out and show them how they have done what's called irreparable injury. That is an American jurisprudence phrase. Now, what we have seen from this type of serving is money that has been paid in the past from any entity, such as your social, as a sole proprietor or an employee, your business EINs, if you work for yourself, you've paid taxes. Well, they have come back in the form of a refund and permanent injunction from ever having to pay. Does this mean they're going to give it to you in one major check? No, it doesn't. They will send it in stipends, in little pieces. Of course, they're going to do that, but that's okay. If you receive something back from a restraining order such as this, that means you are under no liability to pay ever again. None. All right. So let's begin. First, let's recap on the location of the United States, which is precedence. You can click on these links here. It'll take you directly to what we're reading today. the location of a debtor. If we scroll down to section H, it says here the location of United States. Now, the location of United States, not United States of America. Two different things. Both are corporations, but one is located in a specific area, and that is the District of Columbia. Okay? You must know that. Let's go back to our guide. Now, let's look at 26 CFR 301.7701-7. This is dealing with trust, domestic and foreign. And we're going to read a few sections here. So this section here is going to give us an understanding of why we want to have a non-resident alien as our trustee for our foreign express trust. And that is the only way that we can make it foreign. It's all about avoiding the two-test rule. Number one, a trust is a United States person if the court within the United States, and we just looked at this. So it's saying a court within where? The District of Columbia. So a trust is a United States person if a court within the District of Columbia is able to exercise primary supervision over the administration of the trust. This is the court test. Number two, a trust is a United States person if one or more United States persons have the authority to control all substantial decisions of the trust. This is the control test. What is a United States person? If you are a U.S. citizen, if you have a passport and you did not attach an explanatory statement saying that you are a California national, a Moor, a Tamarian, or whatever, if you didn't do that, you are a U.S. person. If you have a birth certificate, you are considered or presumed to be a U.S. person. If you have a social security number or an I-10 number with a green card, you are a United States person. Therefore, you do not qualify to be a trustee of the Foreign Express Trust. You do not qualify to be a trustee under your Foreign Express Trust. Now, you could be the settlor. You are the one providing all of the assets, gifting it to the trust for the benefit of the trust, and having a non-resident alien on the document as the trustee who is managing all of the profits, assets, and all of the property on behalf of the beneficiary. If you list yourself as the United States person or the trustee in this trust, then you have just breached this rule. It is now a domestic trust. You are within the control test. You are within the court test. And if you are ever in a situation where you're trying to use your trust in court, they will breach it and they will control and make a decision on their behalf. You will not have the remedy that you're looking for. So you must have a foreign person who is the trustee. This is called the sole trustee. They are the only trustee attached to your document. Okay, let's go down to 2. A trust is a United States person for purposes of the Internal Revenue Code on any day that the trust meets both the court test and the control test. For purposes of the regulations in this chapter, the term domestic trust means a trust that is a United States person. The term foreign trust means any trust other than a domestic trust. See, they don't really want to teach you right up front how you will be considered a foreign trust. They will always say it is just the opposite of a domestic trust. And you are to figure it out from that point on, meaning you are to get yourself into a situation in court and let the court tell you if you're foreign or not. Let's go to point 3. Except as otherwise provided in part 1 subchapter J, chapter 1 of the code, that means this code, the taxable income of a foreign trust is computed in the same manner as a taxable income of a non-resident alien individual who is not present in the United States at any time. Now, that was a mouthful, but in order for us to understand it, we have to manually search this section here. Okay, so let's go down to, so what I've done here, if you were doing this research yourself, you would highlight this section, copy and paste, and search it within CFR 26. I have done that within this guide. We're going to go straight to it. And it's talking about impositions of tax. We're going to go down to B, talking about the computations. It says the taxable income of an estate or trust shall be computed in the same manner as in the case of an individual, except as otherwise provided. In this part, the tax shall be computed on such taxable income and shall be paid by the fiduciary. Fiduciary is another term for trustee, U.S. agent, authorized representative, authorized person, and so on and so on. For purposes of this subsection, a foreign trust or foreign estate shall be treated as a non-resident alien individual who is not present in the United States at any time. Do you see that? A foreign trust or a foreign estate shall be treated as a non-resident alien individual who is not present in the United States at any time. That is what you want. If a non-resident alien is not in the United States, he's nowhere in any of the several countries of North America, then why would the IRS tax that person? The IRS has nothing to do with them. They would say, if they're dealing with a Colombian and that Colombian is in Colombia or in any else in the world, they're going to say, if he is a Colombian national by his passport, then their form of IRS has to deal with him, not us. And who is his IRS? That would be, I believe they're called, I can't think of the name right now, but it is a 3-letter word or a 4-letter word. I'm drawing a blank on who their form of IRS is in Colombia. But the IRS would have nothing to do with that non-resident alien at all. So that is what you want. You must have that foreign person connected to your trust so that way you are treated as such. Okay? Now, what we want to do, we take this phrase here, non-resident alien individual who is not present in the United States. If you copy that, and search 26 CFR, paste that phrase in, hit enter, it's going to take us to subsection 1.871.7. This is taxation of non-resident alien individuals not engaged in U.S. business. Now, there is a slight way that they can be taxed, a slight way, and you must know how to avoid it, right? So if we go to, let's read A1. This section applies for purposes of determining the tax of a non-resident alien individual who at no time during the taxable year is engaged in trade or business in the United States. However, see also 1.871-8, where such individual is a student or trainee deemed to be engaged in trade or business in the United States, or where he has an election in effect for the taxable year in respect to real property income, except as otherwise provided in subsection 1.871-12, a non-resident alien individual to whom this section applies is not subject to the tax imposed by section 1 or section 1201B, but pursuant to the provision of section 871A, is liable to a flat tax of 30% upon the aggregate of the amounts determined under paragraphs B, C, and D of this section, which are received during the taxable year from sources within the United States, except as specifically provided in such paragraphs, such amounts do not include gains from the sale or exchange of property. That's 1031 exchanges, right? You have a property, you sell it, you have profit from it, capital gains, and you decide to take that capital gains or profit to purchase other property to delay paying a tax. It's not a bad thing if used wisely. Okay. Now, let us go to this one here. This is the determination of tax on treaty income. Now, in the previous law we just read, it talked about engaging in trade or commerce within the United States. There are certain things that you can involve yourself in that's considered a trade or commerce with the United States. Oil, mining, gas, utilities, surveying, agriculture, phosphorus, things of that nature. If you are in a business and you are servicing these agencies, you're considered to be in a trade or commerce with the United States. Now, you can separate yourself. There's a proper way to do it. Let's read B1 in this section. For purposes of this section, the term treaty income shall be construed to mean the gross income of a non-resident alien individual or foreign corporation. As the case may be, the tax on which is limited by a tax convention. The term non-treaty income shall be construed for such purposes to mean the gross income of the non-resident alien individual or foreign corporation other than the treaty income. Neither term includes income of any kind which is exempt from the tax imposed by Chapter 1 of the Code. All right, you guys following me? Follow me all the way to the end here. You're going to see how the tax treaty will relieve you of all these impositions, fines, fees, franchising fees, duties, taxes. This will relieve you of that. You have to let them know how you know what they're doing is based on us paying out of ignorance, because they have the badges, they have the guns, and if we are able to pay and still be able to feed our families, then we're okay. But no, that's not okay. You have to understand that money is a tool. Money is defined as a trade of your labor. So if you put in 40 hours a week and it's taxed right off the top before I give you anything, that means I stole your labor. You would not let me do that. We all understand that when it comes to hiring someone to do work on our land. We must pay them by the hour in which they say. We don't say, oh, let me go ahead and take that tax off the top and give it to the IRS on your behalf. No, we just pay them in full what they're owed. Pay a man what they are due. And the IRS is not doing that. In fact, the IRS is not even an agency, a part of the United States. You're going to see that in the congressional record I have for you. In today's webinar, you're going to receive the necessary income to put this tax injunction together yourself. You have enough tools here in this webinar to do it. But if you want us to do it for you, there's an application that you fill out, we do it, and we get it out there. So let's continue. We read B1I. Now let's go down to 2. In determining either the treaty or non-treaty income, the gross income shall be determined in accordance with subsection 1.872-1. We just read that. And 1.72-2 or 1.882-3 and -3-1. Except that in determining the treaty income, the exclusion granted by section 116A for dividends shall not be taken into account. Dividends from what? Life insurance. That's a tax-free vehicle. Okay, please take advantage of that and learn velocity banking. Use it. Become your own bank. Become your own insurance company. Please use it. Thus, for example, treaty income includes the total amount of dividends paid by a domestic corporation not disqualified by Section 116B and received from sources within the United States. If, in accordance with a tax convention, the dividends are subject to the income tax at a rate not to exceed 15%, but does not include interest, which, in accordance with a tax convention, is exempt from the income tax. In further illustration, neither the treaty nor the non-treaty income includes interest on certain governmental obligations, which by reason of Section 103 is excluded from gross income, or interest by which reason of a tax convention is exempt from the tax imposed by Chapter 1 of the Code. All right? Please watch and read this over and over again to fully understand. Very important. Now, we're going to go to the next section. 26 CFR subsection 1.872-1. This is gross income of non-resident alien individuals. Here we go. The gross income of a non-resident alien individual for a taxable year includes only the gross income which is derived from sources within the United States and which is not effectively connected for the taxable year with the conduct of a trade or business in the United States by that individual, and 2, the gross income, irrespective of whether such income is derived from sources within or without the United States, which is effectively connected for the taxable year with the conduct of a trade or business in the United States by that individual. All right. So that was very important to go over so you understand United States, the location of it, what a non-resident can and can't do as far as engaging in a trade or commerce that is effectively connected. All right. And if like I just said, phosphorus, mining, gold, gas, oils, all of that is considered to be a business or commerce with the United States. So a lot of us are already exempt from that, right? We're not engaging in that. A lot of us are not. So now let's get a better understanding of trade or business within or without the United States. So B, for purposes of this part 2 and chapter 3, the term trade or business within the United States includes the performance of personal services within the United States at any time within the taxable year, but does not include, and then all the rest here. Now, I want you to know this. This is a very key phrase. within the taxable year. If you've received a notice for your foreign express trust saying that you are not required to file 1041s, then you're not within that term taxable year. You're exempt from that. That's how you're supposed to read that. Let's go down to 4A. And I know most of you have received that, and the others are still working to get that letter from the IRS. You will get it. Keep plugging and chugging. Every 2 months, every 60 days, keep sending that correspondence and you will get it. Let's look at 4A. Except as provided in subparagraphs B and C, no income gain or loss from sources without the United States shall be treated as effectively connected with the conduct of a trade or business within the United States. Let's go to B. Income gain or loss from sources without the United States shall be treated as effectively connected with the conduct of a trade or business within the United States by a non-resident alien individual or a foreign corporation if such person has an office or other fixed place of business within the United States to which such income gain or loss is attributed and such income gain or loss. So what did we do when we called the IRS? What address did we give them as the principal place of business? It was indeed outside of North America. You may have a mailing address in North America, but your principal place of business and the establishment of the trust was outside of North America. All of these rules here is how we were able to figure out the process in filling out that SS4 to get the infamous 98 number. It's here right before you. Let's go down to 5. I'm going to go to 5A, rules for application that applies to the above section. 5A, in determining whether a non-resident alien individual or a foreign corporation has an office or other fixed place of business, an office or other fixed place of business of an agent shall be disregarded unless such agent, number 1, has the authority to negotiate and conclude contracts in the name of the non-resident alien individual. Stop right there. Now, isn't that what we have done? Rewind. We've created a foreign express trust where you are the settlor. You've gifted and gave all of the assets of your life estate into this trust. The trust is the beneficiary. Your non-resident alien is the foreign trustee. Now, on the surface, the very first questions that you have all asked me is, how do I prevent this non-resident alien from going rogue and taking all of my stuff? I worked hard for all that. Can he just take my house if I put the house in the trust? Can he just go get a bill of sale and sell my car if I put the car in the trust? Well, what did we do? We had the foreign trustee create a second trust called the trust enterprise, or sometimes otherwise known as the ventures. And because he already has the assets from the first trust, he creates a second trust, placing those assets there. That makes him the settlor. Then he installs a U.S. agent, an authorized representative, a passive trustee, which is you, to operate that enterprise vehicle. So now you're doing things on his behalf, his or her behalf. They don't have to be a part of anything. And this is what the law just said in number 1. This agent has the authority to negotiate and conclude contracts in the name of the non-resident alien. That's what the trust enterprise is all about, to have them within your affairs and at the same time outside of your affairs. Okay, that is a number one rule for the application of paragraph 4B. That's how you do that. That's the whole purpose of a trust enterprise. So now we have to go down and look briefly into the 1041 tax form. If you click this link here to take you directly to it, here's the 1041 tax form for 2022, allegedly, as they say. And we want to go down to everything dealing with us belongs to section 8. So we got to go to page 8. Page 8, here we go. Now you're either going to file a 1041 tax return, 1040, 1120, 3520, whatever, right? Or you're going to do the other option, which is to file a statement. You're going to do exactly what the IRS told you to do when you applied over the phone to receive that infamous 98 number for your trust. And then they sent you what? A letter that says, by a certain date, you are to file a 1041. And you're thinking, wait a minute, I shouldn't have to do that. Well, there are rules in the IRS manual says if you were to receive that in the mail, you are to immediately send us a statement saying why you do not have to file a 1041. And that is what you've all done. Some of you have received that correspondence coming back that says you are off the tax rolls for the federal government. And now we're doing this part right here so we can get back monies that we've paid in the past. Now look at this on page 8. This is coming from a publication, I believe 501. This section here, the first tip, it says, even if you do not otherwise have to file a return. Now, sometimes this is going over a lot of people's heads because in most families, they feel that you must file a return every year. Did you know there are some people that do not have to do that? If you learn the rules of the 0%, you know that you can be a part of that as well. Even if you do not otherwise have to file a return, you should file one to get a refund of any federal income tax withheld. You should also file if you are eligible for any of the following credits. Now, there are a lot of other things that you would file for in this particular sense that is not on this list here. For example, trusts do not pay taxes. We know this very easily. Try to go down to the dealership and finance a car in a trust. They will not let you do it. We just went down to the dealership last night and they said that. Doesn't matter what kind of trust it is. They will not let you file and get financing for a trust. It could be an LLC, it could be a corporation, but it can't be a trust. Why? Trusts don't pay taxes. Well, what are the taxes? The sales tax, and most importantly, the interest applied to principal. So if a trust is not supposed to pay taxes, which is, in other words, interest, usury on principal, then they can't give you a loan. Banks are not interested in giving you a loan just for principal, but they will do it for artificial entities such as LLCs and corporations, right? So there are other things that you would apply for in filing a refund on a 1041 form to get monies back. Think of everything that you've paid that's associated with interest and sales tax. If you've kept your receipts and you can calculate all of that, you'll get it back. Interest on mortgage, interest on car loans, interest on credit cards, interest on student loans. A lot of times student loans will be canceled out with this type of filing. This is what you want to do. This is how you express your trust. Okay, let's go back to our guide here. Now, of course, our trade our trade is not within the United States. So a statement must be given in lieu of a 1040 form or 1041 form, as I just said, right? Now, what is the statement to determine if you are not engaging in a trade or business within the United States? It is Public Law 94-55-0 of October 18, 1976. And you know that as 28 USC 1746. I have you guys always list this phrase at the end of your proofs of service or whenever you're making a jurat acknowledgement. It's stating that you are saying everything that you said in your affidavit is being filed within the United States of America, not the United States of just the United States. This is the unsworn declarations. You've seen this before. One is without the United States and one is within. One is without the United States and one is within the USA. The other one is within the US and all of its other territories. Like I said, this is the public law. So if you're doing business and making statements under that rule, then that's how you keep yourself outside of their territory and their jurisdiction. Everything you send, whether it's notarized or not, it needs to have that at the end or just before your signature line. You must do it. Now, let's go to, now before we get into treaty law or treaty income, we really need to understand just how important plenipotentiary power really is. This position is expressed between the United States and the Kingdom of Morocco in the Act of Algeciras. And we may read about it in Part 3 of Volume 34 of the Statutes at Large. The act it's an act or order from the Sultan of the Empire giving plenipotentiary power to kings, queens, and presidents to run specific territories as an extension of his hand. Okay, so the country of, let's say, Amsterdam, whichever king, queen, or president they have been given that power by the Sultan. Every country is in power by someone else of the empire, which is the Sultan. So let's take a look at that statute. This is very important, and you really want to get a hold of this right here. This is the Statutes at Large of the United States of America, talking about the discussions that they've had when they were at that treaty convention and receiving plenipotentiary power. So when we create our minutes 5 or minutes 6, that's plenipotentiary power, where your foreign trustee is giving some type of assignment to you to operate as a U.S. fiduciary or an agent, so that way you can still utilize that social to get things done in the public. At the same time, you're outside in the private. Well, this is where it comes from, all right? You want to get a copy of this, and you want to list the writings in this document inside of your tax injunction and your restraining order to get your monies back. They will tell you in this document here, they should not be taxing you guys. All right, let's read it. I'm going to read from the top. And whereas the said General Act and additional protocol were signed by the plenipotentiaries of the United States of America under reservation of the following declaration. The government of the United States of America, having no political interest in Morocco and no desire or purpose having animated it to take part in this conference, other than to secure for all peoples the widest equality of trade and privilege with Morocco, and to facilitate the institution of reforms in that country, tending to ensure complete cordiality of intercourse, that means transactions, without, and stability of administration within, for the common good, declares that in acquiescing in the regulations and declarations of the conference, in becoming a signatory to the General Act of Algeciras and to the additional protocol, subject to the ratification according to constitutional procedure, and in accepting the application of those regulations and declarations to American citizens and interest in Morocco. It does so without assuming obligation or responsibility for the enforcement thereof. If they're going to consider you to be a U.S. citizen, you are first always going to be an American citizen, because whether we talk about the de jure or the de facto, the U.S. has always been a corporation from its very inception. Okay, you can have a republic corporation and you can have a democratic corporation. It doesn't matter. So therefore, if you have that birth certificate, you will always be considered a commercial citizen on paper. You'll always have that commercial property that is what it is. When they say American citizens, are talking about that piece of paper that ties you to republic or a democratic corporation. That will always be. But you are indeed something else, right? You are not a piece of paper. So therefore, there's a real you and there's a commercial you. I want you guys to separate yourself and understand that the real you can control the commercial you throughout the commerce that they're speaking about in this document. When they say intercourse, that's not the sexual, that is the financial, commercial intercourse. And you see that referenced in the Articles of Confederation. So if they are considering you to be a U.S. citizen, they're talking about you in this document saying American citizens on the surface. And the country that is the main source here, it is Morocco, which is America. Morocco is the main country here. It's the United States of America Corporation working within this major landmass of Morocco. All right. Now, we're not talking about the state of Morocco over in African continent. No, this treaty here is done or looked upon in 1905 and 1907. If you were to look up when did Morocco become a state, it's going to say 1956. This is completely after. This is a very different thing. Okay, this is the Corporation of Morocco over in Africa. We're talking about the Empire of Morocco. That is who are going to give the major plenipotentiary power instructions to the individuals working as consulates and consulars here in North America. All right, let's continue. And whereas, in giving its advice and consent to the ratification of the said General Act and additional protocol, the Senate of the United States resolved, as a part of this act of ratification, that the Senate understands that the participation of the United States in the Algeciras Conference and in the formulation and adoption of the General Act and Protocol which resulted therefrom was with the sole purpose of preserving and increasing its commerce in Morocco. This is the whole point of why the United States is interested. They want to do commerce in Morocco. The protection as to life, liberty, and property of its citizens residing or traveling therein, and of aiding by its friendly offices and efforts in removing friction and controversy, which seemed to menace the peace between the powers of signatory with the United States to the Treaty of 1880, all of which are on terms of enmity with this government. Do you see that? There's your connection. And without purpose to depart from the traditional American foreign policy, which forbids participation by the United States in the settlement of political questions which are entirely European in their scope. And whereas the said General Act and additional protocol were duly ratified by the governments of the United States of America and of the other powers aforesaid, and by His Majesty, the Sultan of Morocco. And whereas, in pursuance of Article 121 of the said General Act, the ratifications of the said General Act and additional protocol of all the signatory powers were deposited with the government of His Majesty, the King of Spain. Now, the King of Spain is directly under that Sultan, right? And then you get the queens, and then you get the presidents. The King of Spain on December 31st, 1906, thereby constituting a valid exchange of the ratifications thereof. Now, therefore, be it known that I, Theodore Roosevelt, President of the United States of America, have caused the said General Act and additional protocol to be made public, to the end that the same and every article and clause thereof may be observed and fulfilled with good faith by the United States and the citizens thereof, subject to the reservation made in the aforesaid declaration of the plenipotentiaries of the United States, and to the resolution of the Senate, in witness whereof I have hereunto set my hand and caused the seal of the United States of America to be hereunto affixed, done at the city of Washington, right? This was done and sealed. You are under the protection of the Kingdom of Morocco by His Majesty, the Sultan of Morocco. So now when you look at the Articles of Association, how does it start? We, His Majesty's most loyal subjects, all of these members here who have received plenipotentiaries of power, are the subjects of the Sultan of Morocco. And they're coming to set up a British empire, otherwise known as British America. That was the first United States. That's what it was called first. See, you have to look at and understand that the Republic and the Democratic are one and the same as far as a corporation. How they operate is different. A republic is going to go 100% solely off of the constitutions. A democratic is going to create other codes and statutes that existed after the republic and try to get you to be subject to that. It tries to steer you away from the republic. We call that the color of law. That's illegal. If you know that, then you can protect that. And if you tell these people, I know how the Constitution, the Republic Constitution in 1787, how it began. If you can properly get that point across and to other people who are so-called patriotic and believe that paying taxes is a good thing, they need to understand that there is a difference between the 1787 Republic Constitution and the 1789 Democratic Constitution with all the amendments. They have to know that. So the best way I can explain it This sultan is like a secretary of state. And he had received from all of these individuals from the colonies, he had received articles of associations, and he's analyzing it, and he's going to approve or reject that British America can come and be established as a corporation. And they're going to talk about what they can and can't do inside of the articles of association, very similar to a corporation. They put up the articles of incorporation and they send that to the Secretary of State. Secretary of State approves it, gives them a file number, and says, okay, you can do business under these guidelines. What is next? Next is the Articles of Confederation for this country, right? Think of that as the bylaws for the corporation. It goes more into detail. Now, on the surface here, if you look at Article 2, look what they say. We will neither import nor purchase any slave imported after the first day of December next, after which time we will wholly discontinue the slave trade. This is the Atlantic slave trade here. Discontinued, not to have slaves brought into the North American continent. Why? There was a war happening and inbreeding happening. And the law of the Sultan of Morocco said, you cannot give your land and everything that was in your trust over to those that are outside of your blood. But there was intermingling happening. We said, no more slave trade. Everybody's losing their property. So that was the war. That's what it was all about. North and South. We want to give our property to our children who are not of the same blood. And the other side wanted to enforce that or go against the actual rules of the Hadith. So we will neither continue in the slave trade, and we will neither be concerned in it ourselves, nor will we hire vessels. Let me go back here. Vessels, nor sell our commodities. What are vessels? We just looked at that. Vessels of the United States, the commercial property, as commodities. The DTC, the Depository Trust Corporation, they will take your birth certificate as a commodity and they will sell it. And they're doing it today. They're going against the treaty. Why is the Sultan allowing it? All of the people were ignorant back in those days. So he said, I will allow it in a different way, a commercial way, not physical. And you are under the trials of Job. Bring yourself out of her, my people. You have to do a process such as this to bring yourself out of taxation, out of slavery, right? It gets really, really deep when you look at it. It really does. A lot of study goes into that. Now, we read the statutes at large. So now, before we get into the treaties, we have to understand the vessels of the United States. Click this link here. It's going to tell you a vessel of the United States is defined as, it means a vessel belonging in whole or in part to the United States or any citizen thereof or any corporation created by or under the laws of the United States, any state of, right? State of California, state of Delaware, state of New York, all of those are considered to be corporations or sub-corporations under the main one. Territories, Virgin Islands, Guam, Samoa Islands, the Mariana Islands, that's the territory, district, DC, and all of its possessions thereof. But guess what? U.S. citizens, the commercial property, are considered vessels of the United States. That's the most important thing to walk away from this. Now, you can separate yourself. You must separate yourself and control that vessel. Go into the Articles of Confederation, 1781. And we are going to look at Section 4 and 6. Section 4 right here says we have 4 clauses, which is something that we have to really pay attention to, right? Section 4, or 3 clauses. To better secure and perpetuate mutual friendship and intercourse among the people of the different states in this union. So the writings in this is going to reflect from that general act of Algeciras. You're going to see where these Articles of Confederations are getting its information from. When you go to the source, now you know exactly what you're talking about. Now you know how to defend your rights. Now you know how to get the judges to shut up, do what they're told, do as they gave their oath to do, and do right by equity for equity, right? Among the people in the different states in this union, the free inhabitants of each of these states, papers, vagabonds, shall be entitled to all privileges and immunities of free citizens in the several states. And the people of each state shall have free ingress and regress to and from any other state. That means you can come and go as you please, as many times as you want, without being carded or charged, and shall enjoy their commerce subject to the same duties, impositions, and restrictions as the inhabitants thereof respectively, provided that such restrictions shall not extend so far as to prevent the removal of property into another state, of which the owner is an inhabitant. Who is the owner? That is the separation of the commercial person. You are the owner. The trust is the owner. There's 2 parts to this, 2 sides to a coin. We're really going to get into that. I'll show you a little bit later. Provided also that no imposition, duties, or restrictions, this is taxes, on all levels, city, county, federal, state, shall be laid by any state on the property of the United States or either of them. This is your no tax law. This is your no driver's license law. All of that is right here. If any person of or charged with treason, felony, or other high misdemeanor in any state shall flee from justice and be bound in any of the United States, he shall, upon demand of the state from which he fled from, be delivered up and removed to the state having jurisdiction of his offense. And that's fair, right? You can't just kill people and then run away and not be brought back into that jurisdiction to serve justice. Now, full faith and credit shall be given in each of these states to the records, acts, and judicial proceedings of the courts and magistrates of every other state. So if I find in the state of Georgia, if I love their, actually I do, I love their constitution. And if I find in that constitution something that will defend me from being wrongfully charged in my state of California, I can just simply quote this right here: full faith and credit shall be given in every state. And I can now bring Georgia's constitution into California's and get the same remedy as Georgians. Now, and also we say full faith and credit because we want them to take judicial notice of the treaties. Now let's look at the treaty. So the most logical question to ask is, what treaty should be examined whereas all legislative officers are bound to it, including the IRS commissioner? Well, we know the Empire of Morocco, not to be confused with the state of Morocco. They've entered into an agreement with the United States of America in I or J 202, which they have retranslated to 1787 to change the calendar. And that's also known as the Treaty of Marrakesh. It gave birth to several other treaties affecting other ports of the empire, such as the Barbary states. Now let's check out the Morocco Treaty. It's called the Treaty of Peace, September 16, 1836. We're going to go down and read Article 6. Now, I want you to check this out first. It says the following 26 pages of Arabic text are a reproduction of the pages in the original treaty. All of these treaties, all of the constitutions, all of the articles of associations were written in Arabic and translated into English right upon the new discovery of America in the 15th century. The 15th century is where we got the English language. But prior to that, the entire earth was speaking Arabic, Latin, Aramaic, and a few other languages like Spanish. So all of this that we have, our government was originally an Arabic-speaking government. So this that we're reading was translated, and I know they have not given us everything. Remember, I said the original Treaty of Marrakesh was written in J or I 202, and they've moved it up to 1787. Here it is. This was really a J or an I, so it would be I 252. This is 52 years after the Treaty of Marrakesh. Now, if you want to get these original documents, you have to go down to the Library of Congress and tell them that you can speak Arabic, prove it to the clerk, the librarian, and she'll let you into that section to get these documents. Very, very true. Article 6. Now, keep in mind, vessels of the United States, commercial property, which is your name that's on the birth certificate, and the one that is the real you, okay? And your trust is controlling all of it. Keep that in mind as we read. Article 6, if any more, right? If any more, this is the real you, shall bring citizens of the United States, this is the commercial property, the name on the birth certificate, or their effects to His Majesty, the Sultan, the citizens shall immediately be set at liberty and the effects restored, and in like manner, if any more, go here, any more not a subject of these dominions shall make prize of any of the citizens of America or their effects, and bring them into any of the ports of His Majesty, they shall be immediately released, as they will then be considered as under His Majesty's protection. They just told you how to do a habeas corpus. If you have family who are wrongfully charged and they are in prison, this is how you get them out. Let's go to Article 7. No taxation. If any vessel of either party shall be put into a port of the other and have occasion from provisions or other supplies, they shall be furnished without any interruption or molestation. Can't tax me. Article 8. If any vessel of the United States, we just read that, the commercial property, right? The citizen shall meet with a disaster at sea and put into one of our ports to repair, she shall be at liberty to land and reload her cargo without paying any duty whatever. You see, when they were translating this from the Arabic into the English, they're doing the very best they can to explain how in-depth the Arabic language is and what they're really saying. It's almost like the Bible. You'll have literal explanations, you'll have metaphorical explanations, you'll have actual literal people that they're referring to, but they're really talking about specific your physiology of the body, right? They may call an angel, but they're talking about angles of light within your body. So you have to know that. Now, you have to see, what do they mean when they say disasters at sea? What do they mean by liberty of land and reload her cargo, when they started off saying if any citizen of the United States, right? Think about it. Look at the notes here. The notes here says if any vessel, ens legis, or juristic person, the name on that social security card or birth certificate, is met with a disaster at sea, your abandoned estate. Everybody knows the Sesta V Act, right? You're abandoned in the water. You were delivered by your mother and you were given by the birth, right? Your abandoned estate. This is creating the certificate of title, the birth certificate, and put into one of our ports to repair. Whose ports? The ports of the empire. She, the vessel, shall be set free on land to reload her cargo. That's the uncertificated security, the SSN, or in Canada, they call it SIN, right? Social insurance number. Reloading her cargo. What happens when you get a credit card? It's revolving. It's being reloaded. You're getting new credit. This is the full faith of credit of the United States. You should be set free on land to reload her cargo. That means wipe out the debt that they're holding against you or reload. And this is without paying any duties or taxes and impositions. Let's look at Article 14. The commerce of the United States shall be on the same footing as is the commerce with Spain. Didn't we read about the King of Spain in that Treaty of Algeciras? Or as that with the most favored nation for the time being, and their citizens shall be respected, liberty to pass and repass our country and seaports. This is why the Articles of Confederation said you have the right to ingress and regress whenever they please without interruption. There are a few different agencies we have to send this to, you guys. I've done it with TSA and have a specific redress number that I give when I purchase my flights. I don't go through the metal detectors, and neither will you. Article 20. If any of the citizens of the United States or any persons under their protection shall have any dispute with each other, the consul, that's the consulate, shall decide between the parties, and whenever the consuls from our government to enforce his decisions, it shall be immediately granted to him. So they just giving you another party to send. You have to send this to the Consulate of Bureau Affairs. The consulate must be involved, right? Now, we have other congressional records to assist our endeavors in, additionally to the treaties. So let's look at the following. We're going to look at House Resolution 25. This was coming out of Georgia by the Republican Carter Earl L. They call him Buddy. And this was introduced January 4th of 2021. It's still on the table, and they're talking about appealing the entire or abolishing the entire Internal Revenue Service. So you have to use these writings in here to back up what you're stating in the restraining order. So this is House Resolution 25. They consider this the bill, and they call it the Fair Tax Act of 21. Let's go down and read Section 101. Income taxes repealed. The Income Tax Code of 1986 repealing everything. This is your evidence, you guys. Section 102, payroll taxes repealed. Relating to payroll taxes and withholding of income. You need to send this directly out to your employer to say, look, this is on the table, and here's why it's on the table. You need to stop withholding everything. Give me my check in full. That's called a certificate of non-withholding that you will draft up, and you can use House Resolution 25. Go down to estate and gift taxes, repealed. They give an explanation as to why they feel this way. And what they're trying to do is implement a national sales tax, which is exactly what the original Constitution was talking about. It was talking about collecting a tax that was only for the poor, the widow, the needy, the orphan, and such. That was it. All of us would have no problem doing that, giving for those that are less fortunate. That's what a tax was all about when it comes to the biblical treaties. But it has gone out of hand because we have grown ignorant and silent, and now we must speak and speak with the pen. You've all heard that the pen is mightier than the sword. Now, another one to look at is to see diversified metal products versus T-Bow Company Trust. Civil case number 93-405E-EJL. This is an answer from the United States court denying that the IRS is an agency of the United States government, but admits that the United States of America would be a proper party to this action. Okay, so let's check out that. It's going to be right here. Blow this up for you. And this is this actual certified copy from the National Archives. You may gather this for yourself. Like I said, if you want us to do it, this will be included in the paperwork that we send out for you. All right. This went to the United States Attorney's Office. This is the address of where that person was at that time. So the plaintiff is Diversified Metal Products, and the defendant is T-Bow Company Trust, including the Internal Revenue Service. So this company is suing the IRS and suing Steve Morgan. All right, let's go down. I think it's going to be point number 4. Point number 4. This is the claim. It says the United States of America, through undersigned counsel, hereby responds to the numbered paragraphs of plaintiff's complaint as follows. So who is speaking right now? United States of America. And if we go down to number 4, 4, it says the United States of America denies that the Internal Revenue Service is an agency of the United States government, but admits that the United States of America would be a proper party to this action, admits that the IRS has served a notice of levy on plaintiff for funds owed to defendant Steve Morgan. Okay. Admits that the IRS has made a demand on plaintiff for payment of funds owed to Steve Morgan. The United States is without information or knowledge sufficient to form a belief as to the truth of the remaining allegations, and on that basis denies the remaining allegations. All you need to use here is point number 4. The IRS is sending you documentation saying that they are a part of the Department of Treasury. Now, if they are a part of the Department of Treasury, that would mean they would have to be associated with the United States of America, which this says they are. So they are not an agency of the United States government. They will also tell you that they are collecting federal taxes. Federal taxes is not a part of the Treasury. Federal taxes is not a part of the United States of America. Federal taxes is a part of the United States. There's the United States and there is the United States of America. So if they're collecting federal taxes and at the same time stating that they are a part of the United States of America, here is your proof directly from the United States of America itself. You want to use this case as evidence or an exhibit in your restraining order. All right. So Title 26, subsection 7804 will give us the exact manual by the IRS how to collect our money back. This is their procedure. Let's take a look. How to collect your money back. Seven, 804, effect of reorganization plans. Let's go to B. Preservation of existing rights and remedies. Nothing in reorganization plan numbered 26 of 1950 or reorganization plan numbered 1 of 1952 shall be considered to impair any right or remedy, including trial by jury, to recover any internal revenue tax alleged to have been erroneously or illegally assessed or collected, or any penalty claimed to have been collected without authority, or any sum alleged to have been excessive or in any manner wrongfully collected under the Internal Revenue laws. For the purpose of any action to recover any such tax, penalty, or sum, all statutes, rules, and regulations referring to the collector of Internal Revenue, that's the commissioner, the principal officer for the Internal Revenue District, that's the chief tax experience officer, or the secretary of the Department of United States, including the consulate, the consular of Bureau Affairs. That's who they just named. They shall be deemed to refer to the officer whose act or acts referred to in the preceding sentence gave rise to such action. The venue of any such action shall be the same as under existing law. And here is the authority to back up what you're saying. All right, so we are now sending these restraining orders out, and they are powerful. They're getting the job done. I'm going to read to you a little excerpt from the actual restraining order so you kind of get a sense of what will be sent out on your behalf. Let me pull up mine. Okay, I'm going to read it to you. It says, take equitable notice that I, Avery Farrell, the Bay of Los Angeles, doing business as Avery Duval Cottrell, one of the people of the California Territory, hereby declare my nationality as a Californian national, but not a United States citizen per Public Law 94-241, which is March 24th, 1976, Section 302, and the 2016 GPO Style Manual, page 95. You guys have all seen that, talking about your respective nationalities. My place of domicile, 12400 Imperial Highway, Norwalk, California 90650. That is where my birth certificate came from. This is notice of estoppel and stipulation of constitutional challenge to all California state statutes regarding taxes, dues, fines, franchise fees, impositions, duties, and marks of attention between Avery Farrell, the Bay of Los Angeles, a Moor, doing business as Avery Duval Cottrell, a vessel of the United States, whose estate is held with the Avery Imago Dei Express Trust, and then I list the specific EIN number and the Internal Revenue Service regarding taxes, involuntary slavery, whereas protection to persons affects papers and property is the paramount duty of the government and shall be impartial and complete. No person shall be deprived of life, liberty, or property, except by due process of law. No law affecting private rights shall be varied in any particular case by special legislation except with the free consent in writing of all persons to be affected thereby and motion to intervene with an injunction, restraining order for taxes, federal and state for the name Avery Duval Cottrell. That's the opener, right? Now, I'll go to another section to show you how their amendments goes against the previous documents that created them. This is according to the Bill of Rights. Let's check this one out. Amendment 4 protects my property, wages, compensations for my labor from search and seizure, which the Internal Revenue and the state have done in the past and continue to violate the Bill of Rights. Slavery is forbidden in the United States before it began in 1774, as mentioned in Article 2 of the Articles of Association. All forms of slavery was abolished in the United States of America on December 1st, 1774, which includes voluntary, involuntary, or penal slavery, which is treason to the 1787 United States Constitution. Money is defined as a tool to store labor. No tax, dues, fines, franchise fees, impositions, duties, or marks of attentions shall be laid by any state on the property of the United States, or either of them according to the Articles of Confederation. All codes and statutes enforcing the taking of money from any act of labor in first position is slavery and treason, in direct violation of the California Constitution, U.S. Constitution, and the treaties as bills of attainder and ex post facto laws. The Internal Revenue Service and the state have subjected me to double jeopardy for an offense not presented to me or a grand jury, supported by an affidavit of complaint by oath or affirmation under penalty of perjury. No person shall be subject to be twice put jeopardy in the same offense, nor he be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. You see, if I truly owe somebody something, the Constitution says that, let me put it this way. If somebody owes me something and won't pay, what do? You sue them. You have to sue them in court and get a judgment, and then the other person will pay. Why isn't the IRS doing that? They're supposed to sue you if you truly owe a tax. But instead, they send threatening documents to you, and we know what they do, right? So this is what we're doing. Out of all the information that was presented in this webinar, it is listed and documented in a specific way that it makes sense for any person who opens up the envelope and reads it. It's going directly to the necessary persons to make it happen for the refunds and for it to be placed on that do not tax list. All right. So I hope you appreciated this webinar and you are interested in doing a process like this to protect yourself and your family for generational wealth building, go to patreon.com/the0%. If you'd like a consultation, please call 888-899-2262. And we'd love to have a chance to speak with you to talk about your goals and endeavors. If you are dealing with an existing court case of any matter, we can assist you with that information as well. But our team here is mostly going to help you in putting your trust packet together, or you may learn how to do that utilizing the courses on Patreon. So with that being said, I'm going to stop it here, and I'll see you guys in the next video. Take care.